everyone, it's Laura, Real Laura B here on YouTube and Twitter. And I've just been talking to myself for 5 minutes because when I went live, I forgot you have to hit the button twice. So it's been quite a minute, hasn't it? I'm already rusty. I want to welcome everybody today. We have a lot of information to get through, but just a quick comment that I hope you all, individually, your family had an amazing holidays and your new year is starting off well. We've had a lot going on in our community, sadly. At the end of last year, we lost LEP Lady, Jeannie Lawson, who did that amazing petition that just completely blew up over 4 million. We met Captain Corey. Very sad, but uplifting for us that we can make a difference in his life. And that's been positive, and that Johnny sent a video. One of the law tubers that was a big promoter of Johnny's case, etc., and great knowledge, and I learned so much from him. Rick Hoeg from Hoeg Law suddenly had a stroke, and we know he's in rehab now, and he still has a long road. And then, of course, most recently we lost Jeff Beck. And I think it's amazing how this community comes together, and I hope they were able to see all the amazing posts and gives them some comfort. But today we're going to move on with my programs. I'm trying to stay away from she who will not be named, but unfortunately, when I first started covering these lawsuits, it was just Travelers against New York Marine and Counterclaim, and then New York Marine sued Amber Heard. So now I am continuing that series. I'm going to finish it out, and hopefully that's all I'll be bringing up about her. So let me just do my intro for the replay crew, and I'll be right back.
Hi, I'm Laura, also known as the Real Laura B from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer, nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Hey, how are you all? I put some links in the description for the GoFundMe for Rick, for Jeannie. Captain Corey does not have a GoFundMe. My understanding is I put the link to who did the tweet? Andy did the tweet that they have the money going somewhere else, and they also have an Amazon wish list, unless something's changed that I missed over the holidays. That's what I have. So I have those links in the description. And I want to thank you all for coming back, because it's been a while for me, because I had pre-recorded some videos so I can enjoy some time with my family. And everybody is loading in quickly. Much love to you all. I hope you had a good holiday. Yeah. I'm going to try and stick to just what we have today. We have a lot of information, a lot. So let me give you a bit of a bring up, quick catch up. Travelers sued New York Marine. This was back in when they first filed 2019, 2021. I think 2021 they first filed, because they claimed that New York Marine was not working with them, was not coordinating with them, wasn't sharing in the costs, that they insisted on hiring their own independent counsel, not working with them. So they want them to, then their counsel left, and they're like, look, you owe us at least 50% of this $10 million we've had to lay out. New York Marine came back and said, hold up, wait a minute. We appointed counsel. Y'all ignored him. You wouldn't work with him. So they left. So New York Marine filed for it to be dismissed. The judge did dismiss the entire case, but then came back and Traveler said, I'd like to amend our complaint. And New York Marine didn't oppose. And they basically came back with, your counsel did not provide a defense. Therefore, you have to pay us 50% equitable cost. They're still sliding in that you insisted on paying independent counsel, but the judge found that was fine. Oh, I just saw, sorry, Sunflower from Newfoundland. You know, that's where my dad was from. So that's cool. So anyway, that's what that was from. New York Marine, after the judgment came in and Amber Heard was found liable for an intentional tort with actual malice and punitive damages, they sued Amber Heard and said, hey, we're not covering any more of your defense. We're not covering anything else, because she was also fined for the appeal. If Amber Heard had her way, she probably would have filed for the appeal, lost the appeal, gone to the Supreme Court. I mean, this was never going to end. In the meantime, Pamela Johnson was very much involved. We saw her every day in court. I'm finding out now She's moved on and retired, but here she is on LinkedIn. She's working as a mediator. This is public information, by the way. I recently retired from Travelers Insurance and now have embarked on a new role as a mediator. So she's still working. She hasn't completely retired. And what I found interesting when I looked down here, she managed complex litigation involving business torts. That's what she did. That's why she was at the court all the time. So she was involved in complex litigation. And now she says she's became a neutral after a career as a litigator. So she must have, I'm not sure she's still licensed, but she would have been a lawyer if she had a career as a litigator, an insurance professional. So that might also be why she was so involved in the courts, that she has that legal background. But now she's working as a mediator. So she's still working. So I'm not sure what happened that she got retired from Travelers. And we are going to do questions and answers. So this may be a long one. Much love to you all. I so appreciate it. So appreciate you all. So we're going to get right into it because this is going to answer a lot of questions and controversies that I've been seeing. And if you know of any more controversies, let's try and hash those out. No, I don't think she's ever going to get her reputation back, Annie. No. And that goes into the settlement, the appeal, dropping the appeal. But let's see what we've got here. First off, this is the last thing we had. Now, this is, let me make sure I got the right one. This is New York Marine versus Amber. They consolidated the two cases that the judge did, but only for pretrial discovery because some of it overlaps. If this gets to a jury trial, it will be trialed separately. But let's look at this right here. I got stuff in the way. The last thing we knew, Amber Heard was thinking about having this dismissed. Then she was saying it wasn't in the right jurisdiction. She finally came back and said, okay, here's my answer. I guess it is. She finally accepted service. I guess this is the right jurisdiction. And she dropped that argument. So when people saw that, oh, they came to an agreement, you know, I had posted about that and they could see it on here that the conference was canceled because they came to an agreement. The agreement was that Amber Heard was no longer going to claim she was not a resident of California at the time that this was served. I don't know where she is. Don't care where she is, but this is ongoing. So let's look at the last thing that she was supposed to do. She had a deadline of January 5th to file a formal motion on the subject matter jurisdiction. We just love saying that, don't we? Subject matter jurisdiction. She did not file it. She gave up that argument. Then she was supposed to, no later than January 13th, file a motion for judgment on the pleadings and or a stay. She had threatened that she wanted to file for dismissal, but she and Travelers wanted to stay the entire case until the end of the appeal. Well, we know the appeal's been withdrawn, so there's no reason for her to file a stay. So January 13th, that was Friday, no stay was filed. There's a scheduling conference set for January 23rd. Now, New York Marine was supposed to file an answer. Remember, she filed an answer, but she also countersued New York Marine. So New York Marine had to file an answer. They asked for an extension, and they were given a due on or before January 13th. They had to file an answer to her counterclaim. And that's what I was so excited for Friday, to find out what their answer was. And instead, what did we get? We get another amended counterclaim by Amber Heard. So we have an amended answer and an amended counterclaim from Amber Heard. No answer from New York Marine. Obviously, before they file these, they're supposed to meet and confer. So New York Marine now gets an extra 21 days because they have to answer her amended claim. And I find this interesting because New York Marine also filed an amended claim in their Travelers versus New York Marine. I'm sure I had that marked for something important. New York Marine versus with counterclaim against Travelers. But look, they filed a leave. They filed permission. And they're asking for an order granting us to file an amended answer. And lots of times what they've done is they filed the amended answer. And they're showing good cause. New York Marine General Insurance Company may file the stipulated amended answer to Travelers' first amended complaint. So they're filing one, but they asked for permission. And we don't get that with Amber Heard. She didn't file. She just permission. It just showed up. So I'm not sure. I don't think there was a hearing Nothing here says that she was giving permission. It just showed up. But New York Marine must have known because they didn't file their answer. So how's everybody going here? So we know Pamela's moved on to being a mediator. That's the proposed order for them to... People are asking me, is this going to go to a jury trial? And we'll talk about that. We all thought it was funny that Amber Heard's demanding a jury trial after that statement she made to Instagram, how the American justice system failed her because of the jury. That she had a more fair trial, which she wasn't even on trial in the UK with a single judge. But here she is demanding, because she has a choice. She doesn't have to ask for a jury trial. She could have asked for just the judge. But it's a counterclaim, and New York Marine had already asked for it. But I thought you might find this interesting that back on March of 28th, they had a hearing where this is where the dismissal came in. It was ultimately ruled on. But in the argument, we have both Travelers and New York Marine here at this hearing. The court sets up a hearing for further hearing for March 3rd. They all agree. And the court tells the lawyers, very good. Yes, gentlemen. And you guys should tell your respective clients to just buck up and settle the case. And Traveler's attorney says, from your lips to God's ears, Your Honor. So these may settle. It's not unusual. Obviously, the judge is like, guys, find a way to settle this. Now, this was before New York Marine filed against Amber. Yeah. So Amber does. I don't know whether she had a choice since New York Marine had already filed it, but yeah, it's a counterclaim. She could have asked for just a judge, I think. We'll find out. Andrea Burkhart has helped me answer some questions, and I bet she's going to do an amazing deep dive on this. She does really researched analysis on these. So mine is the initial presentation of the docs, and she'll do the deep dive, among other people. Any questions real quick before I get into the first document? And I thought I'd start with, I know you all have been seeing parts of Amber's, but New York Marine that filed their amended counterclaim against Travelers really is a great way to bring us up to date on what's been happening. And it actually answers, to a certain extent, some of the claims that Amber Heard's making. So I thought that would be the best place to start. Wonder who is paying for this. Good question. Insurance is not paying for it unless she came to some deal with Travelers to pay for it. I mean, it's out of the realm of what their policy covers. As far as I know, she's got to pay this herself. It'd be interesting to find out if she has someone else. I just can't imagine that she could get that kind of, she got Travelers to settle for $1 million to pay Johnny, which was $500,000 over their maximum judgment payment. I just can't imagine she'd get them to pay for this. So, yeah. So as far as I know, she's paying for this herself, which could be also why Johnny had to agree to settle for just $1 million, because he knows she's paying for this. He's a good guy. He was not in this for the money, but we'll get to that. Any other questions, guys, before I start? What, if anything, is Elaine? Where'd you go? What, if anything, is Elaine involved in this litigation? She is a fact witness, and as far as she was behind the scenes dealing with Cameron McAvoy, and she will be subpoenaed and deposed. When I say her, it's her whole firm that's being deposed, but she is the one that's most likely going to have to answer the questions. She would be the one that's what they call the MK. I forget what the third letter is, but she's the most knowledgeable in this. Yeah, thanks. I'm glad to do this. 100% worked well last time. Yeah. All right, so let's get into this document. Oh, I forgot. Just to clarify something, Travelers is making a claim throughout this that they were giving Amber Heard the right to choose her own lawyer, and they ended up paying these astronomical fees. Well, this is the letter. I don't have the policy, but I do have the letter where they've accepted the claim, and this is what the coverage we're going to give her. And I think the important thing is, if I go down here, you have retained Brown George Ross from Los Angeles to represent you in this, and we have also been informed that you have retained Kaplan Hecker Fink. She had already hired Roberta. That's important, and I'll remind me to get back to that, but that's really important in what I think happened to Cameron McAvoy. You have already hired Kaplan in the firm to represent you. This is important. While we have the right to select counsel for you, we have no objection to these retentions. Well, that's exactly what New York Marine came in. New York Marine came in and said, look, you have to have a local Virginia lawyer. You've also already retained Cameron McAvoy. So we will appoint them. Now here, Brown, George, Ross, LLP, and Kaplan are not Virginia lawyers. So Travelers knew that New York Marine had already retained or accepted and retained Cameron McAvoy as local counsel. New York Marine also insisted that Cameron McAvoy had to be lead counsel. So Travelers has appointed 2 non-Virginia firms at this point, even though they said we have no objection, but we have the right to select counsel for you. And you're going to see the big argument in here was they kept insisting that New York Marine had no right to appoint counsel, that Amber Heard should have been able to pick her own. Also, furthermore, we only pay the firm the rates we ordinarily pay for work of this kind in this jurisdiction, meaning even though she was insured, it was all insured in California, the home, the business, the underlying action, the lawsuit was happening in Fairfax, Virginia. Therefore, they're only paying reasonable attorney fees that would be normal in Fairfax, Virginia, which is still an expensive area outside DC. Those rates are $290 per hour for partners, $235 per hour for associates, and $110 per hour for paralegals. All associates must have had 5 or more years. So they've laid it all out. This is all we're going to pay. This is it. Invoices should be sent to me via email, and I'll pay them based on the rates described in the application in our guidelines. What the hell happened? And it's signed by Pamela. It's signed by her. Because that's not what ended up happening. So they accepted the claim, and we'll get more information on that. But these are important things to remember. And I'm not sure why New York Marine hasn't brought this up more. How are we doing? A lawyer cannot solicit perjury, which makes them wonder who fired who. As far as Cameron quit. Verdict still stands. Settlement is only for the money paid for the judgment. That's the only thing that was settled in the end. The judgment stands. She's still liable. Everybody knows it. Okay. It's not too long. I know it says 42 pages, but we're going to skip the answer to their amended answer to Travelers. This is New York Marine to Travelers because a lot of it is restated in various ways in their counterclaim. So I'm just going to start with the counterclaim, if you don't mind. Okay, let's see what this one is. This is Defendant New York Marine General's amended answer to the first amended complaint and demand for jury trial. So this is against Travelers. So this is their answer. And again, sometimes it's not going to have a lot of information for us. Hold your eyes, guys. I know you hate this. But it's going to, like here, answering paragraph to New York Marine denies the allegations. That's not really going to help us. But a lot of the meat of what they're saying up here in this document, which I'm not sharing, and I meant to. A lot. Did I not share the letter, guys? Did I miss sharing the letter to you? Shoot. Let me go back real quick, just in case. Here's the letter, just to prove to you, Travelers. I'm so rusty. I haven't been gone that long. Look how rusty I am. That's the letter. That's the background. That's their coverage. Attorney retention. Here it is. You have retained Brown, George, Ross in Los Angeles to reach you, and we've been informed that you have retained Kaplan Hecker from New York and a firm in Fairfax. That's Cameron McAvoy. Oh, no. That's Rottenborn. That's Rottenborn. I forgot about that. In Virginia to represent you. So they're ignoring Cameron altogether. Well, we have the right to select counsel for you. Here it is right here. Well, we have the right to select counsel for you. We have no objection to these retentions. That's exactly what New York Marine did. You've already hired Cameron McAvoy. We have no objections to these retentions. Please be aware, and this is the amounts I read you, those rates are, that's what they're only allowed, 5 or more years experience. They didn't stick to this. And here I just wanted to show you it's signed by Pamela Johnson. And they went cuckoo. Can Elaine be compelled to break privilege at depositions? No. However, when Amber Heard filed the claim, When Amber Heard filed the claim, and I checked this with Andrea, she had to allow, I'm getting up her comment so I say it correctly. She had to allow the insurance companies to talk with her attorneys. She, to a certain extent, had to have waived some kind of privilege waiver. And this is what Andrea said. The policy requires her to authorize us, the insurance company, to obtain records and other information. So sending them all the legal papers, cooperate in investigation, etc. So Cameron McAvoy would be carrying out these obligations to her, same with Elaine. To a certain extent, yeah, she's already waived privilege when she filed the claim to a certain level. To a certain level. Yeah, she wants to place blame on everyone. So that was that letter. So now this is what I was talking about when you have just a, let me blow it up a little bit. See if I can get it any bigger. Yeah. Answer to parent. Look, who wants to see this? This doesn't tell us anything, but a lot of meat in here is going to be repeated in the counterclaim. So watch your eyes, guys, because I got to get down to the counterclaim. If we have time, I mean, I'll provide the link for this when it gets uploaded. It's not uploaded yet. This is their affirmative defenses. Let me get to the meat of the counterclaim. Prayer for relief. This is their answer against travelers. This is their amended counterclaim. This is where we're going to start. So it's not as long as it looks. And it's going to help bring us up to date. Travelers issued homeowners policy to the mutual insured for the policy period of November 14th, 2018 to 2019. So she was covered during the time she wrote the article, which was in December. The traveler's policy was issued or delivered to the mutual insured in California. The coverage provided for traveler's policy extends to otherwise covered or potentially covered damages because of defamation. That's the homeowner's policy. New York Marine is a business policy. The traveler's policy promised a defense to any lawsuit seeking damages. New York Marine issued a commercial liability policy, which provides coverage to the mutually insured for the policy between July 18th, well before she wrote the op-ed, through the 19th, July 18, 2019. So let me remind me to put my screen back up. But I want to start right now and talk about a controversy I've heard a lot. I've heard people saying she took out these insurance policies with the intention to use them to write the op-ed. Therefore, it'd be fraud. And I'm saying I don't agree. This is my personal opinion, but I don't see how this could possibly happen. Amber Heard did buy a house. We've covered this before, where we found that California's a little late in putting things on their public website, and she most likely did contract the house in November of 2018. She then got a homeowner's insurance policy, as any homeowner does, to cover the home, and the traveler's policy happens to have a defamation section to it, coverage in it, and it does for many people, not just for her. I've asked a few people to check their policies, and Travelers does, and I think it's because they have a higher level policy, maybe. I don't know, but they are covered. She had a business. She was speaking. She got New York Marine insurance, and then maybe in July 18th of 2018, she got New York Marine. Maybe they were a better price than the one she had before. Or maybe it was the first time somebody says, hey, if you're going to be doing these speaking engagements, there's a potential for defamation. You better get your policy. And why do I think it had nothing to do with the op-ed? Because Johnny sued her in March of 2018. So why did she wait until September to file a claim? That's why I don't think it had any, I just think it was, I don't think she knew she had coverage. And I'll tell you how I think that came about as we get to more dates. But I don't think her getting the insurance was normal homeowners and normal business. I don't think she knew she was covered for defamation, which is why it took so long for her to apply and make the claims. Just checking to see if there's any. Oh, she brought it all on herself. Yeah. All right. So she wrote the op-ed, and I'm seeing a lot of comments. I'm going to try and stay on this, but yeah, here I decided I missed doing my crafting, and it was covered up behind the backdrop, and I was never taking it down. And the New Year's, I decided I got to get on with my life. I got to do stuff other than Johnny Depp. So that's why this is changed around back here. Let's see. So New York Marine, they got their, so the underlying action is Johnny Depp's lawsuit. In or about March 2019, the mutual insured was sued in Virginia state court. The underlying action, that's Depp v. Heard, sought damages for defamation. The Depp v. Heard, you're going to keep hearing that the underlying action states claims that were potentially within the scope of both Travelers and New York Marine policy, subject to the terms, provisions, and limitations of those policies. And they're talking about defamation. These dates are important. In or about September 4th, 2019, the mutually insured tendered underlying actions to New York Marine. Upon information and belief, the mutual insured also tendered the underlying action to Travelers on or about September 4th. Important dates. We just saw a Travelers letter saying, we see you already hired. Where do we see it? You've already hired Kaplan. You've already hired them. So let's take a quick look to remind ourselves here. September 4th, they tendered a claim. You've already hired Kaplan. And here it is on November 5th. We have Benjamin Rottenborn. He's the one that's just come in. Ben, Treese, Berta Kaplan, Joshua Matz, Julie Fink, John Quinn. These are all of these came in on September 5th. And what had happened was, before that, George Ross, Eric George, and Richard Swartz, they had filed to have this dismissed based on forum inconvenience. Everybody lived in California. All the witnesses were in California. There's no reason to have this in Virginia. And they got denied. And I think at that point, Amber Heard realized, oh, crap, this is not going to be a quick dismissal. I'm in trouble. I can't pay for a full defense. And I think Kaplan, at the same time, was very into Me Too. She had another client against Trump. This was back then for defamation. They're now filed sexual abuse in New York because they opened the door up for the time limits. She filed defamation that Trump had claimed that, I can't remember her first name, I know her last name is Carol, lied about saying that she was a victim of sexual assault. Now, whether Amber Heard reached out to Kaplan and said, hey, Me Too, can I file with the legal fund, which was Me Too in the workplace. So I don't think that, Jean Carroll, thank you, loves cats. So I don't think she could get, but I think she may have reached out to Kaplan or had somebody and said, or Travelers, maybe Pam did, and said, hey, can you represent her under the fund? Well, she couldn't under the fund, but I'm betting, Travelers wasn't involved yet, but I'm betting Kaplan said, well, how are you going to pay me? And Amber's like, I have no money. And she said, well, okay, this is a high profile case. And I'm really interested. Have you checked your insurance policies? This is my speculation. This is what makes sense to me. And Amber Heard is like, I don't even know. What are you talking about? Yeah, lots of times insurance policies have defamation. Check them. And lucky for Amber, she had 2 existing policies already existing that had defamation coverage. So that's how I think that it happened. I think it was not a controversy or a fraud that she intended to defame Johnny, and knowing the insurance was there. She didn't file for it until after she hired Kaplan. Like, obviously this is a day after, but of course they would have been talking beforehand. Kaplan would have wanted new strategy and everything else. What I find interesting is here's Benjamin Rottenborn. They have to have a Virginia-based attorney. They already have Cameron McAvoy. He files notice of appearance. He files by counsel of Amber Heard. Look at all the names. Kaplan, Fink, Quinn, Matz, and that company, and his name. And Eric George. And look, counsel for defendant, look who's missing. Right off the bat, look who's missing. No Cameron McAvoy. Right from the beginning, he's gone. He's gone on all their documents. Motion to admit. Motion to admit. Right from the get-go. Counsel for Amber Heard, Kaplan, Rottenborn, Eric George from California is still there. Cameron McAvoy is gone. Now, why did that happen, do you think? You've got to make me show you the documents, guys. Thanks, McNatty. Quickly. Here it is, September 5th. Here they all are. Rottenborn, Treese, Kaplan. This is the day after she filed the claim. But of course, they would have been talking. I won't repeat myself. But here, thanks for reminding me to share my screen. We have counsel for Amber Heard. We've got Kaplan, Fink, Quinn, Matz, Kaplan, Hecker. We've got Rottenborn, and we've got Eric George, and we have no Cameron McAvoy. They're gone. They did not include them. All of them. Motion to admit Roberta Kaplan. She's in good standing. Kaplan, Fink, Quinn, Matz, Kaplan, Hecker, Rottenborn, Eric George, and nobody. No Cameron McAvoy. Ben Chu, Camille, Adam Waldman. This was the firm he had with Robert Gilmore. Signed by Rottenborg and Joshua Treese. No Cameron McAvoy. They were gone. Gone. Let's see if we can find something quickly. Plaintiff's opposition. This would be Johnny Depp's team filing. Going down, guys, watch your eyes. Oh, I got to go a little further on this one. Ben. Yeah. But if you go all the way to the bottom, I know I'm killing your eyes. You hate that. I just happened to pick a long one. There he is. Certificate of service. They served Eric George and Tim McAvoy. So they're still in the loop. So right from the get-go. Why do we think that happened? I think when Roberta Kaplan agreed to come on, I'm going to leave my hand right here. When Kaplan agreed to come on, she wanted to be lead attorney. She didn't want, and New York Marine said, no. We hired Cameron McAvoy, who you were already hired. They're going to be lead attorney. Kaplan knew she had to have a Virginia-based attorney firm and said, fine, Travelers, Amber Heard, if you want me, I have to be lead attorney. This is my speculation. And I need a Virginia firm. Here in comes Rottenborn, and we're not going to work with Cameron. Somehow that happened. And I think it's because Kaplan wanted to be lead attorney and not have two lead attorneys. And she needed a Virginia firm. This is my speculation. I think that's how that happened. Because right from the get-go, they weren't even letting him know they were coming to the party. I don't understand why he's hanging in there. Whoop. He's the local firm. And when they did the appeal, they still needed a local firm. And he was the person most knowledgeable. So that made sense. And she's going, I don't know, she might be going to do something to blame Elaine. All right. So on September 4th, they accepted the claim. September 5th, it goes public that Kaplan et al., including Rottenborg, file in Virginia. October 1st is when they processed the claim and they've accepted the mutual's insured's defense subject to reserve its rights. So they've accepted the mutual, meaning both Travelers, there's two insurance companies, Amber Heard's defense, subject to a reservation of rights. And that's where they won't be indemnifying her. Thank you so much, Kat. You're terrific too. I appreciate you. New York, this is important. New York Marine appointed the law firm Cameron McAvoy to defend the mutual insured in the underlying action. At the time it appointed Cameron McAvoy to represent the Amber Heard in the Depp v. Heard action, Cameron McAvoy was already representing the mutual insured in that litigation, having been previously selected and retained by Amber Heard. She had already picked this firm and hired them back in March when Johnny first filed. Cameron McAvoy is located in Fairfax, Virginia, and the attorneys retained to defend the mutual insured in the underlying action is licensed inter alia, Virginia, but not in California. In appointing Cameron McAvoy, New York Marine expressly instructed the firm to serve as lead counsel in the defense of the mutual insured in the underlying action. And that's unusual. That's pretty common with insurance companies because they're paying out all this money. They need to make sure that they're somewhat in control. So he wanted his attorney to be lead. Travelers acceptance on October 7th, October 1st, October 7th, Travelers accepted. Agreed to assume the mutual insured's defense in the underlying action subject to a reservation of Travelers' rights as set forth. October 7th, reservation of rights letter offered to provide the mutually insured with independent counsel. They didn't. They said, we have a right to appoint counsel, but we're going to accept Kaplan and Rottenborn, who you've already hired. That's not what the letter didn't say you can hire whoever you want. They did the exact same thing that New York Marine. You already have Cameron? We'll accept Cameron. You already have Kaplan and Rottenborn, although we have a right to appoint someone for you, we're going to accept who you already picked. So this, I think they're not paying much attention to. Following Travelers' October 7th reservation of rights letter, the mutual insured also retained and Travelers funded the mutually insured's defense through New York-based attorney Roberta Kaplan of Kaplan. Well, we already know from her letter that Kaplan was already hired by Amber. So they've gotten their facts a little mixed up, and I hope they go back and look at this again. Pursuant to letter agreements dated April 24th and June 2nd and July 27th, Travelers retained, and this is a new nugget, Travelers retained and paid for the services of counsel with the law firm Eisner LLP, who were presented to New York Marine as the mutual insured's personal counsel. That's Amber Heard. Travelers' agreements with Eisner firm obligated the Eisner firm to assist in interacting with litigation counsel for Ms. Heard in the underlying action. Bad wording. For purposes of providing advice to her regarding strategy and expenditures, and negotiate with New York Marine regarding increasing their contribution towards expenditures in defense of the underlying action. So this is why we're all like, when we found this name that they're going to depose this guy, we're like, why is Travelers paying for an independent attorney? In or about June 2020, the mutually insured replaced Kaplan firm with Virginia-based and licensed attorney Elaine Braderhoff of the firm Charleston Braderhoff Cohen Brown. Well, what happened, right? Kaplan filed the best shot they had. She was there for defamation. She was there for the Me Too. She was there for free speech. They filed to have it dismissed that this op-ed was never about Johnny. Anybody who had a reasonable grasp of the English language knew it wasn't about Johnny. It was only her opinion. And the judge said, yeah, not so fast. We're going to let the jury decide this. So it goes to the jury. So Kaplan was like, I'm out of here. I don't know. She left, claimed that with the lockdown, it was too far for her to travel from New York to Virginia, even though almost all the depositions were in California. And she had some accounts out there, Davita Brooke. Everything else was handling over Zoom. I'm not sure why it was so cost inefficient for her to have a case in Virginia. Then she opens up a new office in DC. So Kaplan leaving is very suspect, especially after it was right after she lost the dismissal. So Amber Heard had to find new counsel. She was expensive. We're going to find out that later. I'm just checking for questions. Okay. In or about, they hired Elaine. In addition to Kaplan and Charleston Braderhoff firm, Travelers permitted the mutual insured, that's Amber Heard, and both the Kaplan and Charleston firms to retain and utilize the attorneys and firms to assist and represent the mutual insured. They were allowed to utilize other attorneys and firms. That's Roberta. That would be Ben Rottenborn, and that would be her personal attorney. So she's got so many attorneys now. Further, although California civil law states that the insurer's obligation to pay fees to the independent counsel selected by the insured is limited to the rates which are actually paid by the insured to attorneys retained by its ordinary course of business in defense of similar actions in the community where the claims arose or is being defended. This entire paragraph is one sentence. Travelers did not enforce this limitation on defense counsel retained by the mutually insured and funded by Travelers. Instead, Travelers permitted the defense counsel retained by the mutually insured and funded by Travelers to bill and receive payment at rates which are higher than the rates which are actually paid by Travelers to attorneys paid by it in the ordinary course of business in the defense of similar actions in the community. Specifically, in or about June 10, Travelers entered into an agreement with defense counsel Elaine Braderhoff was permitted to bill its usual and customary hourly rates without limitation on those amounts, subject to a purported agreement that this would constitute a capped fee of $2.5 million through post-trial motions. So what do I think happened? Kaplan left. They hired Elaine, and Elaine said, fine, but I want the same fees you were paying Kaplan. I think Pam was thrilled to have Kaplan. I remember to go back. I think Pamela was thrilled to have Kaplan. This was height of the Me Too, First Amendment case. They all thought they were going to come out heroes, right? They thought they were going to win. There was an email that said Johnny had slim to nil chance. So they were spending this money willy-nilly. Why? They wanted to win, number one. And number two, she had reserved her rights to an anti-SLAPP defense. If they won, they expected Johnny to reimburse Travelers. Well, obviously he reimburses Amber, but then it goes to Travelers. So they didn't expect to lose. They put the strongest case they had. Money's no object, even though it was supposed to be, because they expected anti-SLAPP and they expected Johnny to lose. And how do I know that? Hold on, because in March, right before the trial, I should have had I had the other one queued up, so I couldn't queue up more than one on the same site. Hold on, guys. If I show you this, I'm scrolling like crazy, and I know people get mad. Hold on. I'm looking for here. Calendar control. Is it either this one? Nope, that's the summary judgment one. What's this one? Set trial for attorney fees if needed. If Johnny had lost, they were on August 15th going to have a hearing to set a trial for them to argue for attorney fees over anti-SLAPP. They were so confident they were going to win that they were spending willy-nilly, expecting that via anti-SLAPP, which in Virginia means that they pay after the fact. You go through the trial, and if you lose, then you have the anti-SLAPP defense, versus California, where you're cut off right away. You don't get to do any discovery. And I've watched Emily D. Baker, and she's had some great opinions on this, that she says, look, anti-SLAPP is great for these vicious lawsuits that are meant to shut people up. But lots of times you'd have a lawsuit like Johnny Depp's that was fair and viable, but he needed discovery to help set his case up, to prove it. And in California, he could have been shut down immediately, which would have been sad and unfair. And that was the issue with these anti-SLAPPs at the beginning, shutting things down before they have a chance to do some discovery. Marilyn Manson is going through that. He wants to delay the anti-SLAPP and do more discovery because he thinks that'll help his case. And I think the judge said, no, don't quote me on that. So in Virginia, they had an anti-SLAPP. It wasn't very strong. Johnny ended up in Virginia, but as the case kept getting delayed, a new anti-SLAPP law was voted in. And he would have had to pay. She reserved that defense, and when she finally filed for it, the judge agreed. When Johnny filed for anti-SLAPP against her on her counterclaim, the judge said no. $10 large bucks to help offset court doc costs. Thank you so much. I really appreciate it. Just Laura. Huge help. Huge help. Back to this. With the cap fee of $2.5 million through post-trial. This was June 2020. Remember, the trial's still 2 years away almost. As of February 2021, Charleston Bradehoff had allegedly already exhausted the purported fee cap of $2.5 million, but trial remained more than a year away. Rather than holding Charleston Bradehoff to the June 2020 agreement on May 18, 2021, Travelers entered into a new agreement with Charleston Bradehoff, pursuant to which it vitiated the original purported capped fee and agreed to continue to pay Charleston Bradehoff ongoing fees and costs on information and belief. By way of new May 18 agreement, Travelers exercised its right under Civil Code, which is this California code, which was with their letter when they said they'd limit it, to limit payments to Charleston Bradehoff to the rates which are actually paid by it to attorneys retained in the ordinary course of business in the defense of similar actions in the community where the claim arose or was being defended, and then only then on an ongoing basis. So Elaine basically got demoted. They said, no, after this, look, you blew through our post-trial money. For now on, you can only charge us this. And I'm not sure this paragraph, I don't know whether this paragraph is as of January 13th, 23, or is this as of May 18th, 2021? As a result, on information and belief, Travelers has incurred in excess of $10 million in defense fees in costs in connection with the underlying action, far in excess of the amounts which Travelers was required to pay in light of the provisions of California Civil Code, upon which it could be initially relieved. They had already spent $10 million. For some reason, reading from previous documents, I feel like that was before the trial started. So you have to add trial costs onto that. But I might be wrong. It just seems to me that this number's been around for many, many, many months, including before the trial started. The conduct of the underlying defense. Following Travelers and New York Marine's respective reservations of rights, Travelers and New York Marine, through their respective counsel funded by each, proceeded to defend the mutually insured in the underlying action. She had Cameron McAvoy, she had Kaplan, who then became Elena Bredehoff, and her co-counsel, Ben Rottenborn, and then she had the personal counsel. Notwithstanding the general nature of New York Marine's reservation of rights letter, Travelers contended that New York Marine was obligated to defend the mutually insured through independent counsel, meaning that they should not have been allowed to appoint counsel. They should have allowed Amber Heard to pick her own counsel. And when Amber Heard made it known, I don't want Cameron McAvoy, I want Robbie Kaplan, New York Marine's like, this is what we agreed to do, and this is what we've been paying for. In furtherance of his position, Travelers embarked on a course of conduct designed to coerce New York Marine into agreeing to share with Travelers in the defense of the mutual insured through defense counsel retained by the mutually insured and funded by Travelers, rather than through Cameron McAvoy, the firm initially retained by the mutual insured and which was subsequently retained as the mutually insured's defense counsel by New York Marine, as was New York Marine's right under the policy. Amber Heard hired him first. We accepted her claim before Travelers did and said, yeah, we'll work with the guy you already hired and his local counsel. As reflected in the April 24th, 2020 and June 2020 letter agreements, Travelers' retention of the Eisner firm was in furtherance of its goal of obtaining New York Marine's participation in its funding of the defense through defense counsel funded by Travelers, rather than through New York Marine's rightfully retained defense counsel. Travelers hired this personal attorney for Amber to advise her that she should not use Cameron McAvoy. Basically, you need to use Travelers Insurance, Kaplan and Bredehoff and Rottenborn. And this is all new discovery. When they filed their original complaint, a counterclaim, they didn't know this. Discovery's been happening. Stuff has been happening behind the scenes. And because of that, they've amended their counterclaim to include this information. Communication between Travelers and the Eisner firm also reflect that Travelers improperly retained the Eisner firm to steer the insured, Amber Heard, away from towards independent counsel, whom Travelers preferred in contravention of her rights under California law. Conflict of interest there. At no time prior to the commencement of this litigation was it disclosed to New York Marines that the Eisner firm had actually been retained by and was being funded by Travelers. On numerous occasions, Travelers instructed and directed defense counsel retained by the insured, Amber Heard, and funded by Travelers to decline New York Marine's requests for information and or applauded and encouraged defense counsel's unilateral statements that it would not cooperate with and or provide information to New York Marine. That's not good. And again, this is all coming from new discovery. For example, in June 2020, Charleston Bredehoff informed Travelers that Charleston Bredehoff was not returning a call from Cameron McAvoy and asking for an update about when the hammer would fall, to which Travelers responded that it could not tell Cameron McAvoy to step down because Travelers had not hired the firm. So Cameron McAvoy, they saw the writing on the wall. And they're calling him like, look, you guys are ignoring us. You're not including us on motions. If you're going to fire us, fire us. It's not up to Travelers. It would have been up to Amber Heard and New York Marine. Additionally, in August 2020, an attorney from Charleston Bredehoff sent Travelers a proposed draft of correspondence intending to be sent from Charleston Bredehoff to Cameron McAvoy, in which Charleston Bredehoff would ask Cameron McAvoy about planning for mutual cooperation and defense of the underlying action going forward. Hey, we want to work for you. Here's a draft letter. We want to work with you. In response, as described by Charles and Bredehoff, travelers slapped the hand of the attorney from Charles and Bredehoff, who drafted the proposed correspondence, and told Charles and Bredehoff to hold off on sending the correspondence to Cameron McAvoy. Anybody want to guess who that lawyer might have been? It's only speculation. But there's only one other Charles and Bredehoff lawyer we know about. Adam Nadelhoff, perhaps? I don't know. Consistent with these communications, defense counsel retained by the mutually insured and funded by travelers consistently refused to cooperate with Cameron McAvoy and deliberately obstructed and prevented Cameron McAvoy's active involvement in defense of the mutually insured. Specifically, defense counsel retained by the mutually insured and funded by travelers frequently omitted Cameron McAvoy and its attorneys from communications with both the court, we saw that, and opposing counsel, and also from case-related emails. Defense counsel retained by the mutually insured and funded by travels also frequently omitted and failed to notify or include Cameron McAvoy in discussions and consideration of case strategy and tactics, and frequently failed to include Cameron McAvoy in pleadings and notices, including by removing its name from the pleadings, proofs of service, which I showed you, and other notices. This is going to blow your mind. In or about August 2020, the Charleston Bredehoff firm entered into stipulation to continue the trial without, meaning continuing the trial, putting in a later date. We're going to have to postpone the trial. We're going to continue it without including Cameron McAvoy in discussions surrounding the stipulation, without notifying Cameron McAvoy that such a stipulation was contemplated, or without including McAvoy on the stipulation or related proofs of service, with the result that Cameron McAvoy only learned that the stipulation and the court's resulting order to continue the trial, to postpone the trial through the court's publicly available docket. They found out the way we did, guys. They found out on the Fairfax court site that the trial that they were working on was getting postponed at the request of their own client. That blows your mind. Travelers has inhibited and obstructed New York Marine's ongoing participation in the defense of the mutual insured by failing to timely provide copies of status reports, invoices, billing audits, and proofs of payment, despite New York Marine's multiple requests to both travelers and defense counsel for such documents and information, including by failing to either request that defense counsel provide such status reports, by failing to assist upon their provision as required of independent counsel under civil code, and or by instructing and or encouraging defense counsel to not share all or certain of such invoices, status reports, and other relevant information with New York Marine, despite New York Marine's request. So here again, we're getting into, somebody was asking me about privilege. Obviously, when she filed these claims, they had to communicate with the lawyers. She's given them permission, so they're supposed to file these status reports, which obviously would not be normal outside of counsel. How are we doing? Any questions here? I'm watching it fly by. Travelers was aware that defense counsel, which it was funding, refused to cooperate with and facilitate Cameron McAvoy's firm's participation in the defense of the mutually insured. This is really hurtful to Cameron, and let me get to the dates and I'll explain why. Indeed, in a March 21, 2020 email to attorney Sean Roche of Cameron McAvoy, Pamela Johnson, Travelers Assistant Vice President Claim Professional, that's who she is, was responsible for handling the underlying action on behalf of Travelers, expressly acknowledged that she had spoken to defense counsel about billing and sharing work, etc., and stated that her conversation with defense counsel did not go well. They did not want to share or work with Cameron McAvoy. Notwithstanding Travelers' March 2020 conversation with them, defense counsel continued to refuse to cooperate with or facilitate Cameron McAvoy's active participation in defense of the underlying action. Travelers therefore both failed to insist that defense counsel cooperate with and facilitate the full and active participation of the Cameron McAvoy firm in the defense of the mutually insured in the underlying action, and require defense counsel's cooperation. They say the same little thing with a lot of words. With Cameron McAvoy, as is authorized to do under civil code. As a result of defense counsel refusal to cooperate or facilitate its active participation in defense, November 6, 2020, the Cameron firm withdrew from its representation of the mutually insured in the action. They withdrew on their own. Now, why would they withdraw on their own? Because at this point, they were having no voice in strategy. They were not being informed with what's going on with what they're filing. They were not being informed in billing. They were not being informed in any step of this. And if Amber Heard turned around and tried to sue her counsel, which would include Cameron McAvoy, they're like, no, you can't sue us because this isn't our fault. They wouldn't work with us. And if you're not going to work with us, we're not going to accept the potential liability of a future lawsuit for malfeasance. We're out of here. Thank you, Patty. Gee, that's so nice. I so appreciate it. It is a huge, huge help. Yeah. You can't see the other side of the room. It's not all that tidy. So yeah, now we've had that's basically caught us up to what's been happening, except that they have the new information. So now we have the first cause of action, and this is part of their counterclaim. I'm going to skip what they've already covered. There was on January 6th, they had already filed motions to dismiss Travelers' claim. On January 6th is the order, and a lot of what New York Travelers is continuing to claim, including Amber, was covered in the January 6th order. So that's why this is important. New York Marine's October 1st reservation of rights did not trigger any right in the insured to independent counsel since, as this court has already concluded in its January 6th order, the reservation of rights issued by New York Marine is a general reservation of rights, which is not sufficient to create a duty on the insurer to provide independent counsel. The judge agreed that they had every right to appoint their own counsel, and they appointed who she was using anyway. Additionally, because the underlying action was litigated in Virginia, state court and the Cameron McAvoy firm and the attorneys appointed by New York Marine to defend the mutually insured, to defend Amber Heard in the Depp v. Heard case, are licensed in Virginia but not in California. No conflict existed between the mutually insured defense counsel and New York Marine. Consequently, New York Marine's reservation of rights did not trigger the right of the insured to the independent counsel, which the court agreed. I don't understand, why are these insurance companies still paying for her attorney? I thought H wanted to just move on. As far as I know, they're paying for, this is before the trial. This is before the trial. Once the appeals were withdrawn, nobody's paying for anything except for the judgment that Travelers agreed to. Thank you so much. I appreciate it. Caradon, thank you so much. So again, the judge has already ruled on this stuff. Accordingly, New York Marine did not owe a duty to defend the insured through independent counsel because its reservation of rights did not trigger the right to independent counsel as a matter of California law. And the court in this case has already concluded that. I don't have to read this word for word. There is no conflict of interest because Virginia-based attorneys appointed to defend the mutually insured could not have a conflict. No obligation existed on the part of New York Marine to defend the mutually insured through independent counsel under California law or the provision of California law. It's a lot of gobbledygook today. Thank you so much, Diana. I so appreciate it. This is a lot of repetitive. New York is informed, believes, based on the first minute. Okay, this is an important paragraph. New York Marine is informed and believes, based on the allegations of Travelers, the first amended complaint herein, as well as the discussions, correspondence, and documents exchanged between New York Marine and Travelers, that Travelers disputes each of the foregoing contentions, and that accordingly an actual justifiable controversy exists. Thank you, Diana. Did I get you before? Just making sure I did. Elong, thank you. An actual justifiable controversy. This is important keywords. It's going to come back and haunt Amber. Let's make this bigger. I'm not reading this whole thing. Don't worry, guys. So they're looking for a declaratory judgment here. So they want the judge to make decisions. But even if they don't agree with the judge, they still have a right to a jury trial. Here in America, we still have rights to jury trials. The judge can't take that away. So that's the first thing. But under the Article 3 of the U.S. Constitution, a federal court, which is what we're in right now, may only issue a declaratory judgment when there is an actual controversy. Without an actual controversy, the federal courts do not have jurisdiction to hear the case. For an actual controversy to be found, the plaintiff cannot be merely seeking advice from the court, but instead must show that the controversy between the parties is substantial, immediate, and real, and that the parties have adverse legal interests. Okay? So this judge can't even hear this case in its courtroom, in the federal courts, unless the parties agree that there was actual controversy. Justiciable. Catching questions between paragraphs. Wherefore, New York Marine is entitled to a declaration that it owed no duty to defend the mutually insured in the underlying action through independent counsel, both because, one, its reservation of rights did not trigger the mutually insured's right to an independent counsel as a matter of California law, and the court concluded this in January 6th, 2022. A lot of repetitive. I know, I'm sorry, they're important. Because under Virginia law, the Virginia licensed attorneys of Karen McAvoy firm, which the New York Marine appointed to defend the mutually insured, could have no conflict of interest. So there was absolutely no reason. And again, this is against Travelers. New York Marine did not fail to provide a defense to its mutually insured. They're going to reiterate that they did provide from their letter with reservation of rights. They did not breach their obligation. They provided someone. New York is informed and believes, based on the allegations of Travelers' First Amendment complaint herein, as well as the discussions, correspondence, and documents, that there is an actual justiciable. So they are entitled to a declaration that it did not breach any duty to the mutually insured. We provided a lawyer. We did. She's a great lawyer. Hey, Just Laura. Thank you so much. I think, did we remind something? Because I think you said that before. God. We have a lot of repeat. I don't think you have to go back. But basically, New York Marine said, like, we did everything we said our policy would tell us to do. We did it all. We provided a defense. You interfered. So Travelers is asking for 50% of their costs. That's where we are now. New York Marine hereby incorporates by reference all the prior paragraphs. I haven't been reading this line by line, by the way. From the outset of New York Marine's participation in defense of the mutual insured, Travelers has wrongfully contended that New York Marine owed a duty to defend the mutually insured through independent counsel, and in particular that New York Marine was obligated to reimburse Travelers for 50% of the fees and costs it incurred in funding the defense. Counsel retained by the mutual insured and thereafter participate in its funding defense counsel on a 50-50 basis ongoing forward. That's pretty much what's left of Travelers' claim, is the equitable division of costs. In agreeing to defend the mutual insured, Amber Heard, through the selected defense counsel, Travelers failed or refused to exercise its right to limit amounts paid to defense counsel to the rates that are actually paid by Travelers to attorneys in business and similar actions in the same area. Instead, entering into improvident agreements with defense counsel, pursuant to which defense counsel was permitted to charge and Travelers paid higher rates and fees than the rates and fees which Travelers could have limited counsel to undercode the civil code, and then ultimately failed even to enforce the limitations on defense counsel fees were contained in its agreements. We saw the letter, right? We saw the letter. Travelers was aware that defense counsel consistently refused to cooperate or facilitate the participation of New York Marine's appointment counsel with Karen McAvoy firm in the defense of the mutually insured, but whether through its negligence, indifference, or as part of a deliberate scheme to obtain New York Marine's participation with its ill-conceived and improvident agreements with defense counsel, Travelers failed to insist upon and obtain defense counsel's agreement to cooperate with and facilitate the full and active participation of Cameron McAvoy. Not only did Travelers apparently want Cameron McAvoy out, or Amber Heard, or Kaplan, or Elaine, but they wanted him out, and they wanted New York Marine to pay for half of the cost that Travelers was piling up. Travelers failed to insist upon and obtain defense counsel's agreement to cooperate. We read that. As a result of the inequitable conduct of Travelers, the Cameron McAvoy firm withdrew November 6th. So Travelers even has the date wrong. Following the November 6th withdrawal of Cameron McAvoy firm and for the mutual insured's defense in the underlying action, New York Marine, subject to reservation of rights, has to date paid Travelers at least a sum of $621,000, reflecting 50% of the fees and costs from November 6th, when Cameron left, to February 28th. One of the reasons they paid that amount was that's all the bills they gave them. They hadn't given them any more bills. And there is the check to prove. There's a check. Rewrite your check, people. For $621,693.43. There's a check. Whoop. This is in court documents, and that's as far as I'm going to go. There's the check. So they did pay. They did pay Travelers money. Notably, New York Marine had previously agreed to make the payment before Travelers disclosed that Travelers was funding the Eisner firm as personal counsel. That's why they stopped paying. They're like, whoa, wait up. Who is this lawyer? Personal counsel for the insured, or that Travelers and the Eisner firm had coordinated to prevent independent counsel, Cameron McAvoy, that would be Kaplan and then Bradehoff, retained by the insured and funded by Travelers, from cooperating or involving Cameron McAvoy. So they're claiming they hired this independent personal counsel to advise Amber and everybody else that we want Cameron McAvoy out. So we're just going to ice them. Despite requests from New York Marine, neither Travelers nor independent counsel retained by the insured and funded by Travelers provided New York Marine with routine status reports, communications, or updates, nor did Travelers or independent counsel retained by the insured and funded by Travelers timely provide New York Marine with copies of all relevant invoices, billing, audits, and related materials reflecting all amounts incurred by independent counsel. So far, it seems fair to me that New York Marine is like, yo, dudes, we hired a lawyer for Amber. It was one she already picked. You hired your own lawyers. You're supposed to coordinate with us. Our guy was supposed to be lead counsel. Obviously, Kaplan didn't want that. So you iced him out. We did our job. Travelers' conduct in entering into improvident agreements with defense counsel pursuant to which Travelers agreed to pay his defense counsel amounts in excess of what Travelers was obligated to pay, and failing to enforce limitations which were in their letter, in failing to require the defense counsel, whether voluntary or otherwise, cooperate with and facilitate Cameron McAvoy's firm's full and active participation in defense underlying action. They write long sentences, people, I'm telling you. Full and active participation in defense and underlying action, and in failing, provide New York Marine with copies of all these reports, invoices, and everything else. And what is the end of the sentence? Fees incurred by Travelers to defend the mutual insured after the November 6th withdrawal of Cameron McAvoy firm from the mutually insured's defense, and which requires Travelers to reimburse New York Marines, which New York Marine has previously paid to Travelers under reservation rights. My God, that was a lot of words. Under California law, where an insurer properly offers a defense through appointed counsel and Amber Heard refuses a defense, neither Amber Heard nor Travelers, which fund Amber Heard's defense, may recover from the non-participating insurer, New York Marine, for sums incurred to defend and or indemnify the mutually insured. That's the point. The refusal of Braderhoft and Kaplan, retained by Amber Heard and funded by Travelers, to cooperate with or facilitate the active participation of Cameron McAvoy in the defense of the mutually insured in the underlying action, and Travelers' failure to obtain or enforce defense counsel cooperation, contributed to and resulted in Cameron McAvoy's withdrawal from the defense, amounts to a refusal by the mutual insured and or Travelers' defense rightfully extended by New York Marine, and unclean hands by Travelers. Unclean hands. This is going to get repeated. I'm going to skip a little bit forward. Travelers is not entitled to recovery because they caused the problem. Again, they are informed and believe that there's an actual controversy. That's important. These are the important new claims. This is what I really wanted to get to. Right now, we've brought you up to date, but this is the stuff I really wanted to get to. New York Marine is now added a fourth course of action: tortious interference with contract. This is against Travelers, not against Amber. That's going to come out later, I bet. New York Marine had a valid contract of insurance with Amber Heard under which it had the right and duty to defend Amber Heard against certain claims, including those asserted by Johnny Depp, at all times relevant to the allegations and claims set forth in this amended counterclaim. Travelers was aware of the existence and validity of New York Marine's contractual arrangements in the mutually insured. I don't know what her earnings were, but I assume that she was using that. She was an employee of that company, and I assume that extended out to her being paid for her speaking engagements, and she didn't give that money to that company. I don't know. The contract, yeah, basically they don't indemnify is what it says. But that was only for the judgment. Now we're in for the defense. Notwithstanding its knowledge of the valid contractual relationship between New York Marine and Amber Heard, Travelers intentionally interfered with the New York Marine's relationship with Amber Heard. Specifically, Travelers sought to prevent and obstruct New York Marine's provision of defense to the Amber Heard through Counsel of New York Marine's choosing, Cameron McAvoy law firm. That's their right. Travelers' intentional conduct prevented performance of New York Marine's contractual arrangements with the mutually insured and made that performance more expensive and difficult. Travelers intended to disrupt New York Marine's performance or knew the disruption of New York Marine's performance was certain or substantially certain to occur. As a result of Travelers' conduct, New York Marine was harmed. For example, the Cameron McAvoy firm withdrew from the defense of the mutual insured from Amber Heard, thereby damaging and interfering with New York Marine's rights under its contract with Amber Heard by preventing it from providing a defense for Amber Heard in the underlying action through counsel of its choosing. Travelers' conduct was a substantial factor in causing New York Marine's harm. This is another one they added, which is a big deal. Which document is 94? This looks like a 99. I can't put the link up to this document yet. I don't own it yet. Andrea shared it with me. It hasn't come up on the site yet. I've tried. Attorneys apparently have different access to Pacer Monitor than my non-attorney Pacer Monitor. So this document was not up for me to buy yet. When I can, I will do the link. This is a big one. Common law tort of another. I'm wondering why they left this out. Because look up here. Against Travelers. It doesn't say against Travelers. So I have a feeling this common law tort of another may apply to both of them. Maybe in their answer to Amber Heard. Travelers wrongfully interfered with and obstructed New York Marine's contractual rights and obligations with respect to the defense of the mutual insured in the Depp v. Heard. As a result, Travelers' wrongful conduct, New York Marine was and has been required to retain attorneys and has become obligated for other costs and expenses which are the result of the acts, errors, and omissions of Travelers. They're going through the throat. New York Marine is entitled to complete indemnity from Travelers, including an award of attorney's fees on account of the cost, expenses which it has borne and incurred as a result of Travelers' wrongful conduct, any costs and expenses that New York Marine has or will occur in this or any related litigation arising out of defense of the underlying action. This and any related litigation. So now they're throwing in the New York Marine versus Amber Heard and her counterclaiming them. They're saying any expenses related to in related litigation arising out of defense of this underlying action arises solely out of and on account of the wrongful conduct of and the acts, errors, and omissions of Travelers. New York Marine is entitled to damages from Travelers in an amount according to proof. So they're going to be providing proof of what they're owed. So they're asking for a declaration of the judge that they did not owe a duty to provide mutually insured with independent counsel. They want to be awarded a judgment in favor so they get this money back. They want a declaration that they did not breach any duty. They want a declaration because they entered into the improvident agreements that even if you think we should pay half, even if you agree to that, we're not going to pay half of the exorbitant amounts they paid for. Declaration that New York Marine is entitled to reimbursement for any additional costs. Okay, jury demand. Why do we have a jury demand? I know we have a right as citizens to a jury. And even if the judge makes a declaration, I thought I had it here. Here. Right to a jury trial and declaration of relief. I'm not going to go through this whole thing. But basically, an insurance company faced with a claim where, after completing a thorough and fair investigation, it concludes that the evidence available to insurer leads to it to conclude that the claim is not by the terms and conditions of the policies, has available to him to deny the claim. This is what they're saying. Hey, this is an intentional tort, so we're not going to deny it. I think that's my iPad going off. Sorry. Pay the claim to avoid litigation, or file a complaint for declaratory relief seeking the advice of the court whether the insurer's decision to deny the claim is correct. That's what they're looking for here. I'm going to get down to the opinion. Insurers should stand by their principles. Paying him and filing a declaratory relief action did not help. By their pleadings, they admitted that they were not sure he was disabled and wanted the court to resolve the lack of certainty without giving entry to the right of a jury trial. Insurers should never deny a claim unless they have conducted a thorough and fair investigation and conclude from investigation that a preponderance of the evidence will prove that there is no coverage under the policy. There is really no middle ground. The coverage either applies or it doesn't. Insurers must decide. But they cannot take, where is that sentence? We have a right to a jury. So even however this comes out, you can't take away our right to a jury trial. But this will play into it. So that was that. That's the check they paid. This is their claim against Amber Heard, and it's only a few pages. I'd be pissed. I'd be pissed if she squandered loads of the money, thousands of documents, and he's staying in a $22,000 a month property while the trial was on. Depp's team stayed in the hotel she has to waste some money. Yeah, I mean, we're thinking, yeah, it's definitely cut and paste the contract paragraph stating intentional tort not covered, that each jury verdict, case closed. Yeah, they have to do a lot of repeating. Travelers were sure they would win. They absolutely were. They backed the wrong lying horse. They did not get the anti-SLAPP, so they're not getting reimbursed. And I think that plays heavily into when Pam retired and a new person came in from Travelers with the appeal. They saw the amicus briefs, they saw the appeal filed, and they were like, oh, hell no, we're getting out of here and cutting our losses before Depp has a chance to answer. What does it take to get us out of here, Johnny? And Depp team said, hey, this was never about money. We wanted to win. We wanted to be clear his name. He got his story out. The jury decided that he was telling the truth and she was lying. That's all it was about for us. Well, our client is now on another lawsuit. She doesn't have the money to pay for you. What can we agree to? And I think Travelers finally said, look, we're going to cut our losses. We'll pay you $1 million and we'll end this. And there's definitely going to be a confidential agreement. Absolutely. Absolutely. So skipping to the information, we don't need to go through the trial stuff and the history. We can go right to the cause of action. This is what New York Marine is suing Amber Heard for. The jury's factual findings established that Heard's liability is caused by the willful acts of Heard as a result as a matter of California public policy and pursuant to California Insurance Code. The policy does not provide coverage for Heard's liability as reflected in the judgment order entered on June 24th. The order's done, people. Here's the judgment order. It's so ordered. This order is filed. It's entered June 24th. I don't know why they keep saying it's not final. The judgment's final. And that's exactly what New York Marine is saying here. The judgment's filed. It's done. An actual controversy has arisen and now exists between plaintiff on one hand and Heard on the other with regard to the duties and obligations owed between New York Marine and Amber Heard under the policy with respect to the judgment order. Plaintiff contends that it has no duty to indemnify Heard for the judgment order entered on June 24th. Plaintiff is informed and believes, and on such information and belief alleges that Amber Heard disputes plaintiff's contention and asserts that the policy provides indemnity coverage for Heard for the judgment order entered on June 24th. The judgment order is the $10 million and $3.5 million. $350,000. Due to the actual and present controversy described, because remember, you have to have that to be heard in this case, in this court, in federal court with this judge. Due to the actual and present controversy described above pursuant to that code, plaintiff requests a judicial declaration of the rights, duties, and obligations under the policy, determining that if said judgment order entered on June 24th, if it becomes the final on appeal or otherwise, well, we know they withdrew the appeal, so the final order stands. Plaintiff has no obligation to indemnify Heard for the judgment order. Say, I ain't paying you. The appeal didn't go through. We're back to the final judge. It was an intentional tort. We're not paying half of the $10 million. Ain't gonna or half of the $8 million if you net out Johnny's. Second cause of action. To indemnify Heard for any judgment. Again, California Insurance Code says an insurer is not liable for a loss caused by the willful act of the insured, but he is not exonerated by the negligence of the insured or if the insured's agents or others. This provision is an implied exclusionary clause, which by statute is read into all insurance policies. As a matter of California public policy, the policy does not provide coverage for Amber Heard's liability to debt. An actual controversy has arisen and now exists between plaintiff on one hand and Heard on the other with regard to the duties and obligations owed between plaintiff and Heard under the policy with respect to the indemnity for the underlying action. Plaintiff is informed and believes, and on such information, the belief alleges that Heard disputes plaintiff's contention and asserts that the policy provides indemnity coverage for her and for any liability which may be established. No. Due to the actual present controversy described above pursuant to 28, plaintiff requests a judicial declaration of the rights and duties, etc. The underlying action, his duty to defend, here we go, the underlying action. Based on the jury's factual findings regarding Heard's liability to debt, required a finding of willful acts by Heard to establish liability. New York Marine, the code precludes New York Marine from having any obligation to defend Heard in the underlying action. An actual controversy, I have to keep saying that, guys, it's going to come important, has arisen and now exists between plaintiff on the one hand and Heard on the other with regard to the duties and obligations owed between plaintiff and Heard under the policy with respect to whether New York Marine is obligated to defend Heard in the underlying action. They're talking about the appeal. He said that we're done. We don't have to cover the appeal. We covered your legal defense and you lost. And it's a willful tort. If you want to appeal it, we're not paying for it. Plaintiff again is informed and believes on such information and belief alleges that Heard disputes plaintiff's contentions and asserts that the policy obligates New York Marine to continue to defend Heard on an ongoing basis. Due to the actual present controversy described above, pursuant to the obligations, you're asking for the judge to decide. Plaintiff's duty to defend and indemnify Heard in the underlying action under the policy conditions. It's basically going to be the same thing. An actual controversy arises, now exists between plaintiff this is an older one. I want to get to her answer. Plaintiff has no duty to indemnify Heard for the judgment order entered. That's the final order that's entered. She was found willful, so they don't have to indemnify her, which means allow her to be intentional. Plaintiff has no duty to indemnify Heard for any liability in the case. Plaintiff has no duty to defend Heard on an ongoing basis, and they want their money and they want their costs, of course. Now we're going to get into Amber's. I hope I haven't gone too fast, and I know it's been muddled, and I know they like to use a lot of words. Final order stands, absolutely. Johnny Depp settled the money part of the judgment, not the case. He agreed to withdraw his appeal. If she would withdraw her appeal, she says, fine, but I can't pay you $8 million, the net amount. I don't have it. So he said it was never about money, and the insurance company's in the middle saying, hey, what can we do to end this finally? And what number can we agree to? They agree to a number, and they have a confidential agreement. Regardless of what Amber Heard put in her little IG statement about there's no gag order, there is a confidential agreement preventing things that can be said and not said. Okay, I'm reading 94. I don't own 94. I mean, I can't tell what it is where I'm looking at right now. At the top, I see the numbers. The numbers were changing on me. So up, can you see my little arrow? Yeah, I'm on a different number now, but I'm sorry. I don't own it yet. As soon as I do, I will provide a link to this. Yeah, I just don't own it. If she ends up posting it, good for Andrea. And I know she's transparent. That's why I don't have an issue. But she has it already, and she's going to do a video. She probably will post it. If it comes up in the next 24, 48 hours that I can get it, I'll give you an example. Here we go. Anytime I get a blue guy down here, that's a document I can get. These are documents I have to buy. It just so happens all I have is this permission to leave. On here, all I have is permission, amended supplemental. This is the Amber Heard one. Sorry. I'm following a lot of them. All I have down here for Travelers versus them is a stipulation to leave. I don't have the document. This is only the proposed order. It's only 3 pages long. I don't have access to it. I don't have access to it. So this is Amber's answer. I'm not going to go for her answer. I'm more concerned about her counterclaim. But why did I keep bringing up controversy? And I want to look at what Andrew was telling me. To make sure I get this right. Let's go to her first answer. Answering paragraph 36. Ms. Heard denies that there is an actual and present controversy regarding New York Marine's duty to indemnify Ms. Heard for any judgment, settlement, or other award against her in the Depp lawsuit, because the Depp lawsuit has been settled with another insurer paying the settlement amount. Therefore, Amber Heard is not seeking indemnity from New York. So she's saying, we're not taking this from you. We don't want any more. Answering paragraph 39. Ms. Heard admits, this is the third cause of action, admits that there is an actual controversy in this paragraph. Admits that there is an actual present controversy. Ms. Heard denies that there's an actual controversy. Anytime she denies something, if they argue it, the judge won't hear it because it's not part of this federal court. And this is what Andrea was advising me on. Did you see in Amber's amended answer how she's trying to say there's no live controversy because she's no longer claiming anything from New York Marine? That's going to be news to travelers. She's putting them in a position where they may now have to sue her too, because she's trying to waive rights that they're actively exercising on her behalf. That's going to be interesting. She denies that there's an actual controversy. In this paragraph she missed, there is an actual controversy in describing her answer. So some of this she's contending that has to be taken out. So in this one, to indemnify her and her duty to defend, she's saying there's an actual controversy. We're going to get, it comes into her counterclaim more. That's why I don't want to spend a lot of time on all of this. So let's get back into, this is her amended counterclaim now. How are we doing over here? Any questions? Yeah, we covered that. If that were true, then why did she wait months and months and months to file a claim? You know, she's going to claim she's like $100,000 out of pocket. And that's probably from March 1st when Johnny filed up until September when she filed the claim and it was accepted in October. So from March to that, she had all of the work that Eric George and Rick Schwartz did and Cameron did, McAvoy, to try and get that dismissal on the venue on form inconvenience. I'm out of source today. I've been not doing this for a while. I'm off count. I'm off beat somehow. I hope this is making sense, y'all. We're hanging in there. Yeah, I don't think any of this is being covered by any insurance. Because even that Eisner guy isn't a party, isn't her counsel here. And I'm interested why he's not. Because I guess he's implicated now. He's got a conflict of interest. Jury verdict stands. Absolutely. I'm just going down real quick. Laura, you're doing great. Appreciate it. Thank you, Jazzy. I really do appreciate it. So now this is her amended counterclaim. We've skipped the answer because a lot of it is reiterated here anyway. We know what the nature of the action is. We know the jurisdiction. We know who the parties are. And this is where we're going to get into a problem. Because New York Marine already complained about Travelers bringing up ProCite. ProCite's not a party to this. Travelers didn't sue ProCite. Travelers sued New York Marine. New York Marine sued Amber Heard. ProCite did not sue Amber Heard, and neither did this other company she's bringing in. So apparently they're going into this big umbrella of who might be associated with this company. But that's not who's suing. Right? Let's go to this one. Oh, I know you hate this. I got cords in the way. Travelers Commercial Insurance versus New York Marine and General Insurance Company. That's it. They're not suing ProCite. They're not a party to this case. And Amber Heard's going to try and make other companies complaints against them. New York Marine and General Insurance versus Amber Heard. These people that she's now going to try and bring in her complaint in many, many paragraphs I'm going to skip is not a party. Ms. Heard is informed and believes, and on the basis alleges that at the time New York Marine sold the policy, New York Marine was part of the ProCite Specialty Insurance Group, and that ProCite advertised and made public statements, including on its website, on the behalf of New York Marine and other members of the companies. I'm not going to go through all those. They were in her last one. She's going to go on and say how they claim to do great customer service, and they market this on their insurance products. But basically, ProCite, unless she's going to add them as a party, this is a waste of paper. So I'm going to keep going. Ms. Heard is informed and believes, and on that basis alleges that Coaction uses its website to represent the nature of its insurance products, which includes ProCite and on behalf. She is informed and believes, and on that basis and alleges that when Coaction says things through its website, advertising and statements, it's speaking on behalf of and is authorized to speak on behalf of New York Marine. They're going to come back and say, they're not a party here. We're the only parties. So I'm not going to waste reaching this because look, she's pulling out all these, she's so desperate. She's pulling out all these customer service and we are experts quotes from Coaction on their website. Not going to waste your time. New York Marine sold the insurance policy to Ms. Heard for July 18th through July 2018 to 2019. The named insured is Under the Black Sky as per named insured extension schedule, which schedule includes Ms. Heard as a named insurer. That's how she was covered. The policy contains multiple coverage parts, each of which provides several separate coverages to Ms. Heard. The commercial liability, general liability coverage form provides $100 million to any one person for personal and advertising injury. So for each occurrence, so the only thing that most they would have paid Johnny Depp is $1 million. Anyway, the policy's commercial general liability coverage forms coverage B, personal and advertising liability, obligated New York Marine to pay those sums that Ms. Heard becomes legally to pay as damages because of personal and advertising injury. Commercial general liability coverage form, it is also obligated New York Marine to defend Ms. Heard against any suit seeking damages for personal and advertising injury. So there's two separate amounts. They have to provide a defense. There's no dollar minimum on that or maximum on that other to say we pay local standard cost. Then the second coverage is if there's a judgment and you're not found with actual malice, we'll pay $1 million max. It's also obligated New York to defend her, which she did. The policy defines personal and advertising injury to mean injury including consequential bodily injury arising out of one or more of the following offenses: oral or written publication in any manner of material that slanders or libels a person. And this is why I think she might have gotten the insurance, because she was being an activist. She was doing all these speaking tours and being paid for it. So I think that's more why she was interested in this insurance, just in case. The policy's comprehensive personal liability coverage obligated New York Marine to pay up to its limit of liability for the damages of which Ms. Heard is legally liable if a claim or a suit is brought against Ms. Heard because of personal injury caused by an occurrence. So this is where she's saying you need to indemnify me. Who cares if it's an intentional tort? Your policy still says it has to pay. The comprehensive personal liability coverage also obligated New York Marine to provide a defense, which they did. Expense at counsel and provide a defense at its expense by counsel of its choice, even if the suit is groundless, false, or fraudulent. Of its choice. So she agrees that New York Marine had the choice. Arising out of one of the following expenses: oral or written publication. To the extent not waived or otherwise excused, Ms. Heard has complied with the terms and conditions contained in the policy, except that she lied, according to the jury, unanimously. Therefore, Ms. Heard is entitled to all benefits of the policy. The Depp lawsuit, we know when it was filed, June 2022, the jury in the Depp lawsuit returned a verdict against Ms. Heard for 3 counts of defamation. Ms. Heard appealed the judgment to the Virginia Court of Appeals in December 2022. The parties finally resolved the Depp lawsuit pursuant to a confidential agreement. The judgment's part of the judgment. The judgment's part of the ruling. The ruling's done, filed, recorded. It is the final ruling. The appeals were withdrawn. The final ruling stands. The only thing that was left was the judgment amount. That's what they have resolved pursuant to a confidential agreement. New York Marine breaches and bad faith conduct. Ms. Heard timely notified New York Marine of the Depp lawsuit. New York Marine initially agreed to defend Ms. Heard subject to its reservation of rights. Unfortunately for Ms. Heard, New York Marine's performance never lived up to its promises. Indeed, leaving Ms. Heard to incur hundreds of thousands of dollars in defense costs not paid by any insurer, withdrew from Ms. Heard's defense, expressly repudiated its duties to defend Ms. Heard, and has consistently placed its interest above those of Ms. Heard. Leaving Ms. Heard incurred hundreds of thousands of dollars in defense costs not paid by insurer. Well, I don't think that's a fair claim, because what she's basically saying is, watch your eyes, guys. Everything from the point when this was filed on March 1st, all these motions, all these letters, all these lawyers, George and Schwartz that she hired, there'll be Cameron McAvoy, defendant's motion, domestic motions. I mean, there's lots of them in here. Remember, then she also wanted the motion to defendant's motion to dismiss. That was the big one. There was hearings on that. There was, they had to do the whole hearing with the judge. They had to file all kinds of motions. They had to do a lot of research. That probably cost hundreds of thousands of dollars by the time the order came through. They also issued subpoenas. And then it wasn't until up here that they hired new lawyers. So of course, and then they filed for the insurance. So yeah, She may have, but not, that was before she filed the claim. So that's, remember, these are, what does Emily say? Emotions or allegations and shade. That's a little shade there. Specifically, in October 2019, New York Marine reserved rights to deny coverage on the ground that Ms. Heard behaved intentionally, thus creating a conflict of interest with Ms. Heard and giving Ms. Heard the right to independent counsel, with New York Marine being obligated to pay for the fees and costs of this independent counsel. No. Nonetheless, New York Marine refused to agree to defend Ms. Heard through independent counsel. They never promised independent counsel. That was never part of their letter or deal, and instead appointed its own counsel. Despite requests from Ms. Heard to reconsider New York Marine's persistent in its position, making it impossible for Ms. Heard to fully accept this defense provided by New York Marine without prejudicing her defense in-depth lawsuit. New York Marine's appointed counsel ultimately withdrew on November 6th. They're taking a lot of their information from Travelers, I think, because they got the wrong dates. So what they're saying is, I didn't like your lawyer. I had better lawyers. And because you wouldn't dump your lawyer and come to our side, I got stuck with a bad defense. And then they finally left. Ms. Heard is informed and believes, and on that basis alleges, that New York Marine thereafter agreed to participate in defense of Ms. Heard, reimbursing Ms. Heard's defending insurer, Travelers Commercial Insurance Company, for some of the amounts it had paid and was paying towards Ms. Heard's defense in the DEP lawsuit, but has never done so. Well, we already saw that check. We already know they did. So she's getting wrong information again. Thus, at no point has New York Marine fully honored its duty to defend. Well, that was because right after they paid, they found out she had private counsel that was interfering with their appointed counsel once discovery started. Once judgment was entered in the DEP lawsuit in accord with the jury's verdict, New York Marine took the position that it need not defend Ms. Heard, even though that judgment was not final. It's final on the paperwork. I don't know what she's talking about. Ms. Heard is informed and believes, and on the basis alleges, that New York Marine took this position to benefit its own economic interests at the expense of Ms. Heard's interests. And even though it knew, or should have known, that the basis for its position are contrary to the law and did not excuse New York Marine from its duty to defend Ms. Heard, including its duty to pursue and fund an appeal for her on behalf of the DEP lawsuit. That's really what it comes down to, that they should have funded her appeal. By refusing to provide the defense to which Ms. Heard was entitled in the DEP lawsuit, and by wrongfully asserting that Ms. Heard was not entitled to indemnity for any amount that Ms. Heard might be legally obligated to pay in any judgment in or settlement of the DEP lawsuit, the New York Marine wrongfully repudiated and refused to perform its duties to Ms. Heard. In so acting, New York Marine deprived Ms. Heard from receiving the full benefits that she was promised and to which she was entitled under the policy. Well, Travelers paid for everything. You know, once everybody came on board, so she's not out of pocket for anything other than this lawsuit. I like that one. Next lawsuit for, I would say, if she has a benefactor, I could see her going after Elaine or Karen McAvoy. She just seems to be that type of person. Yeah. Just double checking to see if there's any questions. So she's claiming her first count is that New York Marine was in breach of contract. Ms. Heard alleges and incorporates by reference paragraphs 128. Now, Travelers already tried this in the other lawsuit way early on. New York Marine filed to dismiss it, and the judge sided with New York Marine. So this is going to be interesting. New York Marine had a duty under the policy, the law, and the insurance industry custom and practices to fully defend Ms. Heard against the DEP lawsuit. New York Marine's duty arose at least at the time it received notice of the DEP lawsuit and continued until the DEP lawsuit was finally resolved. I don't think so. They had a duty until the judgment came in. New York Marine also had and has a duty under the policy, the law, and insurance industry custom and practice to promptly conduct a full and thorough investigation, including as to all bases that might support Ms. Heard's claims for the coverage. New York Marine also had and has a duty to give at least as much consideration to Ms. Heard's interests as it does to its own interests. New York Marine, they said that they thought DEP had a slim to nil chance to win. And they did conduct, and based on everything they saw, they believed Amber Heard. New York Marine breached its duties by, among other things, refusing to fully and properly defend Ms. Heard in the debt lawsuit, repudiating its duty to indemnify. They clearly say under California court they don't have to indemnify, and the judge already agreed to that, for any amounts that Ms. Heard might have been legally obligated to pay in judgment in or settlement of the debt lawsuit, otherwise refusing to perform its duties under the policy. As a direct and proximate result of New York Marine's contractual breaches, Ms. Heard has sustained and continues to sustain damages in the amount to be proven at trial, currently exceeding $75,000. I thought the other said she incurred hundreds of thousands. So right now she's saying she has sustained and continues to sustain damages in $75,000. She's going to have to prove that. Not hundreds and thousands anymore. Implied in the policy is a covenant that New York Marine would act in good faith and deal fairly with Ms. Heard, would do nothing to interfere with Ms. Heard's right to receive benefits due under the policy, and would give at least the same level of consideration to Ms. Heard's interest as it gives to its own interest. New York Marine also had a duty under the policy, the law, and the insurance industry custom, practice, and standards to conduct a prompt and thorough investigation, including as to all bases that might support Ms. Heard's claim for coverage before asserting coverage defenses or denying coverage. Well, at the time of the coverage, they'd already lost the venue, but they didn't have access to the dismissal. I showed you they had just started issuing subpoenas. And in fact, if I go to California, 10/29/2019 is the first time they started getting involved in compelling subpoenas and whatnot in California, which was after Kaplan. Lost my there. Is this the one? Yeah. Implied in the policy and the coverage agreement would act in good faith and deal fairly with Ms. Heard, would do nothing to interfere with Ms. Heard's right to receive benefits. I wonder what it has to do with having Ms. Heard interfere with New York Marine's appointment of counsel. Instead of complying with these duties, New York Marine acted in bad faith by, among other things, refusing to fully and properly defend Ms. Heard in the debt lawsuit and then repudiating its duty to defend, refusing to indemnify Ms. Heard to its policy limit as to any judgment in or settlement of the debt lawsuit. Well, the California Code says you don't get indemnified. Failing to fully inquire into possible bases that might support coverage for debt lawsuit, asserting grounds for limiting coverage that it knows are not supported by and in fact are contrary to the terms of the policy, the law, insurance industry custom and practices, and the facts, taking coverage positions that are contrary to Ms. Heard's reasonable expectations of coverage, giving greater consideration to its own interests than it gave Ms. Heard's interests based on information and belief, failing to have appropriate claims handled guidelines, and failing to consider and act in accord with the governing legal requirements. In breach of the implied covenant of good faith and fair dealing, New York Marine did the things and committed the acts alleged above for the purpose of consciously withholding Ms. Heard the rights and benefits to which she was entitled. New York Marine's acts are inconsistent with the reasonable expectations of Ms. Heard, are contrary to established insurance industry custom practice, are contrary to legal requirements, non-California codes. The standard insurance is we don't indemnify. We don't cover intentional torts. Are contrary to legal requirements, are contrary to express terms of the policy, and constitute bad faith. These are all one sentence. I don't know what did they get a new lawyer writing these things? As a direct and proximate result of New York Marine's breach of the implied covenant of good faith and fair dealing, Ms. Heard has sustained and continues to sustain damages in the amount to be proven at trial. Ms. Heard is also entitled to recover all attorney's fees that she has reasonably incurred and continues to incur in her efforts to obtain the benefits due under the policy that New York Marine wrongfully has withheld and is withholding in bad faith. Ms. Heard is also entitled to interest on the maximum legal rate. Hang in there. Ms. Heard, we're almost to the end. Ms. Heard is informed and believes, and on that basis alleges that New York Marine, acting through one or more of its officers, directors, or other corporate employees with substantial independent and discretionary authority over significant aspects of New York Marine's business, performed, authorized, and or ratified the bad faith conduct. And she hired the independent attorney or travelers paid for it to block Cameron out. New York Marine's conduct is despicable and has been done with conscious disregard of Ms. Heard's rights, constituting oppression, fraud, and or malice. New York Marine has engaged in a series of acts designed to deny Ms. Heard the benefits due under the policy. Specifically, New York Marine, by acting as alleged above in light of information, facts, and relevant law to the contrary, consciously disregarded Ms. Heard's rights and forced Ms. Heard to incur substantial financial losses, thereby inflicting substantial financial damage on Ms. Heard. New York Marine ignored Ms. Heard's interests and concerns, the requisite intent to injure, and within the meaning of the California Code Civil Section. Therefore, Ms. Heard is entitled to recover punitive damages from New York Marine. To punish them and make an example that New York Marine and to deter similar conduct in the future. Where have we heard that from? Oh, yeah. In Fairfax, the jury awarded Donnie $5 million. In the amount sufficient to punish and to make an example of Amber Heard and deter similar conduct and claims in the future. Too bad they had to reduce it. For damages according to proof at trial, for damages. So right now she's out of pocket $75,000 plus whatever this lawsuit is costs for this suit, etc. So that's where we're at. The order entered. The order is final. We saw that. I don't know whether I had anything else I needed to show you. So that's where we're at. There's a lot. And I don't think New York Marine's going to be too happy that she jumped in there with an amended complaint without leave from the court. Yeah. So has anybody got any questions? There's one big controversy I'm hearing about. So we covered about, I don't think her insurance was fraud. I think she just happened to have it. I don't even think she knew about it, which is why, or she knew she had coverage, which is why she did not file until after Kaplan came in. I think Kaplan came in and wanted to be the lead attorney, and that's why they brought in Ben Rottenborn and why they were not working with Cameron McAvoy, because New York Marine says you are the lead attorney. I think Amber Heard maybe contacted her hoping for the legal fund, the Time's Up legal fund, but this doesn't cover that. And Kaplan was very interested. It's a high-profile case. She wanted to pay mucho money. Travelers agreed. Pam, thinking anti-SLAPP case, would you get reimbursed? Because they really expected to win. What other controversy? So Kaplan left after she lost her dismissal, and Lane came on, and I'm assuming she said, I want to be paid the same as Kaplan. This is a high-profile case. We're going to get anti-SLAPP. And we know that because they wanted to set a trial for the attorney fees if needed. That means if Amber won, for August 15th for the hearing. In case I messed that up earlier. Is there any other controversies that you'd like to ask me about? Because I have one more. Yes, I have the GoFundMe's in my description down there. Okay, I'm hearing controversy about the settlement and whether she now has freedom of speech and whether Johnny can sue her again. And I think this has been covered by a few of the law tubers. If you look at her Instagram statement, now we now know there's definitely a confidential agreement. For her to say there's no gag order, I disagree. I'm sure there's something in there that says you can't claim that I abused you. Can't say that anymore. And if you notice, that's the one thing she did not say in her Instagram statement. If there's no gag order, she talks about her truth, but she doesn't actually come out and say, I'm a victim and Johnny did this. She has, maybe her father abused her as a child. Maybe she'll come out with stories about casting couches. But I don't believe she's going to be able to come out outright against Johnny. Defamation per se. Johnny already adjudicated that in the op-ed. Or no, sorry. Yes, per se, by innuendo. And defamation per se, meaning he doesn't have to identify damages. He already adjudicated in this. How many times can he be damaged by innuendo? Once she claimed it was against Johnny and he proved that she lied, she lied. Nothing's going to change that. He's already adjudicated those three statements, and that included by innuendo. So she continues to tell these stories where people assume it's about Johnny. Well, he already adjudicated that, and no one's going to believe her. No one is going to believe her. The second part of defamation that's important is if she comes out right with a brand new claim, brand new allegation, Johnny's going to have to prove damages. And would he really and truly be damaged or damaged defamation per se just assumed to be damaged because it's an egregious claim, if she's already been proved to be a liar, that nobody should be believing her anyway. Nobody's going to, I cannot believe any reputable organization or company would hire her to be a spokesperson, an activist, to get on a stage and speak into a microphone, anything that would be related to her prior claims that were just adjudicated, that she was unanimously found to have lied with malice, with punitive damages. That's a hell of a risk. I just don't, she's a liar. Nobody's going to believe her. That's number one. I don't think a book publisher would take the chance of publishing any document, pages, chapters of these claims after they've been adjudicated, even with some kind of release. Like up on the op-ed site right now, the first thing you see is a statement saying this has been found, she's been found guilty of libel for this article. And they still have the article up. So it comes down to, if she does something again, and let's say a concert venue says, nope, we're not going to let Hollywood vampires play here because of her latest claims, that's damages. That creates damages. Yeah. You cannot be given a gag order in the United States unless it's so very specific because of our freedom of speech. And she was never gagged, even with the original confidential agreement. She was never gagged. The jury didn't issue an order to gag. So come up there. I know she damaged her own reputation. There's nothing she can do about it because she is dumb and down about it. All she has is her little coven of friends over there. And Eve, I think, is back in LA. Who knows where Amber is? But I just can't imagine anybody actually hiring her. Like, they can use her case and say, oh, gee, this is terrible that a woman who made these claims was, social media just dragged her. That shouldn't happen to any so-called person who claims abuse until it's proven. And she was just annihilated in social media. Was that right? Well, audio tapes did that, where she personally, on her own audios, admitted, yeah, I instigate physical violence and I can't promise I won't do it again. Yeah, I hit you. They're her audio tapes that we were all basing our opinion on. Yeah. MSM protecting her after her L shows. Depp is still being targeted. He always will be. And it will be the minor. I think MSM has lost interest. The public's lost interest. So there's no benefit for them. Remember, I talked about this outrage economy that they will put in their headlines, clickbait, to piss everybody off. They want to piss both sides off. But because Johnny has the bigger fandom, if they piss us off, we'll click more to correct them and yell at them and comment against them and share them by commenting. And they just make more ad money. They're just more popular. It's so hard to sit on our hands when you want to correct them. But I wouldn't be bothered with mainstream media. I wouldn't be bothered. I think we covered everything. And I'm sorry there was a lot, because this last document came up so quickly. I will link down her. Oh, again, and she wants jury demand. Isn't that the end? Yeah. Claimant, counterclaimant, New York Marine hereby demands jury trial, and Amber Heard. Defendant counterclaim Amber Heard hereby demands a trial by jury on her counterclaims. So I guess that snuffs out her IG statement too about having no faith in the USA judicial system. I hope I've helped. I'm a little rusty. I was sputtering a little bit back there. I have some links. I'm not going to read them to you. I'll put them down there. This is explaining that how is it that Cameron McAvoy, for example, can talk to New York Marine, tell him what's going on. And it's because, and I explained that as far as privilege, when she filed the claim, she waived a certain amount of her privilege that the lawyers had to be able to talk to the insurance companies. They had to give them reports and updates and strategy. So it makes perfect sense. And if Cameron's strategy was, hey, we're being excluded over and over, yeah, they needed to tell New York Marine who was paying. Is it possible that the confidential agreement included a clause that if she does X, then the original judgment could be revoked? Yeah, it could. If she runs her mouth, Johnny could go back after the, what would be left? 7 million, 7.35 million. it could very much include that. Very much. But that would be on her. I don't think it would be on Travelers. Travelers is agreed to settle. And that is in their letters and their policy that the insurance companies have a right to investigate and settle it on their own. I know that was in an engagement settlement. Oh, thanks, Secret Miss Squirrel. I appreciate you so very much for all that you do. I'm checking. I think sometimes she'll jump into my chats on Twitter, and I don't look there. Yeah, the GoFundMe's, but please, yeah, push them. Push them. NBC's learning the hard way. Look, they took the whole side of Amber, and now they've hired Camille. I think that's interesting. I think that. Am I missing any GoFundMe's that are going on that from the community? I don't think so. I think I've got them all. Any other controversies? So we've got the settlement. We've got, obviously, our insurance lawsuits are still going forward. These are not getting settled, although the judge certainly suggests they settle. They tend to settle. The declaratory relief, the declaratory judgment is a judge, tell us who's right and wrong here. But apparently it's not binding. Here in the United States, we have a right to a jury. But I imagine whatever the judge decides can be part of the facts. And I hope that's something that Andrea will cover in her. In fact, I'm going to send her an email. Can you cover why they're doing a declaratory judgment and still get a trial? And I know it's because we have a right to trial. And they're just trying to set up the facts at this point. Thank you, Pam. I so appreciate it. And Pixie Doll, thank you. Oh, it's my chair. I know, it's my chair. Sorry. It squeaks. Now, there it goes. Yeah, you think it's your chirping battery? Is that it? I'm just a noisy person on this end. I got rid of that notifications on my computer, but I brought my iPad up to double check some of Andrea's comments, and I can't get it turned off. Nick Wallace sent the first draft of his book to the publishers today. Sounds awful. Does that mean that you guys have seen the draft? I am so glad to keep helping. I'm not going to do a lot of Amber Heard coverage other than it applies to this insurance. So going forward, I'm going to try and just promote Johnny's good works. Trying to, what other lawsuits are we working on? Gary Jacob, a little update on that. She is suing Taylor Lorenz and New York Times. Let's face it, this is an uphill battle with the New York Times. They're so used to this. The judge did allow Taylor Lorenz and New York Times to file another dismissal, but Gary has the right to oppose it. So it's going to go through the whole shebang, so it's not over till it's over. As far as, I don't know what's going on with Depp versus Jackson. This has been interesting to me because they keep filing for extensions. And I've lost it again. They keep filing for extensions. So they were originally supposed to provide their answer to Johnny's complaint in December. Then it got postponed to January. And now I think it's February 1st. They just keep filing for extensions. So I don't know what that means. I don't know whether they're trying to settle it or whether they can't come up with a decent answer to help them win. I don't know what's going on. But they's out. They's out. She will be able to file bankruptcy with these final expenses. Maybe. I remember they were saying that she couldn't with the judgment. I know that. I was supposed to get my hair done today, and they called in sick, and I was thinking I'm going to do my first live with fresh hairdo, and no. Get over it. It's nature. Yeah, that's what I'm thinking. Johnny Depp's team already pulled the copyright. Well, you saw his entire team is back. They already pulled any copyright papers, and they didn't find anything on this. Nothing. Yeah, I've never found. Now, I got to tell you, these documents were the driest I've had because a lot of them were repetitive. Although I found it really cool that they're going after travelers now for torturous conduct against travelers and torturous conduct by a person and nothing in parentheses. So I'm wondering if that's going to be coming, or it was anticipated to come out in their answer to Amber Heard's counterclaim, but she beat them to it. So if they have to wait, they'll be waiting 21 days. Uh, yeah, it's Dubai. It's Saudi's trying to get more of a broader culture. So they have a whole ministry of culture, movies, arts, theater, all of that, women, including women, to try and get more movies and get involved. And this will be their first foray into Europe. They did try to get into Hollywood with Endeavor, and I think they got ran out because of the journalist. So, oh, wow, that's great. Our likes are almost matching our viewers. That's awesome. We did great. Andrea's awesome. She's amazing. I want to send you a big hug, Laura. Thanks so much for your coverage. Amber has the money. She hasn't spent all the $7 million. I mean, let's think about it. She got $7 million from Johnny. She got money from Aquaman at the time, and then Aquaman 2. She got money from L'Oreal. She got money for all those speeches. She got paid for all of them. She got money for the charities because she was using that Todd Krim organization. So that's paid for. She doesn't do those for free. She got paid for her speeches. She's done some other movies since the divorce. She got paid for. She just did a movie this past year. It hasn't been released, but she got paid for it. She's made money. What have her expenses been? She got sued for Nicola 6, and that got dismissed because the other company went bankrupt. So I don't understand why she doesn't have the money to pay this judgment. I really don't. I don't know if Elon is the father of the child. If Elon is he paying some kind of, child support, or did he put a trust up for the kid? I don't know. I don't know if he's the father. It seems pretty possible. I mean, Daily Mail came out and said Elon Musk is the donor. I mean, they came out and said it. She sold her, I think she netted about $500,000 cash. She had to pay off the mortgage. I think she sold it for a little over $1 million, wasn't it? So I think she netted about $500,000. Oh, well, we know she didn't because Johnny was responsible for all her liabilities. He paid $7 million to her. Ed White said it was close to $7.5 million at least of debt he had to pay off that was agreed to, and he had to give her the $7 million tax-free. So he said it came close to $30 million on paper, because he had to pay the taxes too. She wouldn't pay. Normally, if you get alimony, your monthly alimony, you don't pay tax on it. If you get a lump sum, you have to pay tax on it. And they're like, why do you want it tax-free? You're donating it. I forget how many years that it goes for Melody. She has so many years before she reinvests that money. Yeah. Where is this from? Tess, did you when you said and, is there another? I don't know. JD's management agency, you embezzled money of his. The manager testified for her. Ugh. Yep. Goes to her booze fund. I like that. I swear to God, she's a cat with 9 lives. So I hope she's held accountable for this, for her to get out of that lawsuit with insurance paying for it. Now, this is what else was explained to me. People were saying, how does she get away saying that she couldn't pay the donation because she had to pay all these Johnny sued me and I had all these legal costs. What a lawyer told me was that it's pretty standard that you're not allowed to tell the jury the insurance is paying for it. Because you've paid that policy, therefore you own that policy, therefore you own the payout, basically. So essentially, it is her money. It's sort of like making an investment. It is her money. She paid the monthly or yearly cost for this insurance for however long. So essentially, she paid. And I think it's pretty standard. I was told that they're not allowed to tell the jury insurance is covering it. Any other questions, guys? We've been on 2 hours. I never go this long. I try and limit it to an hour to an hour and a half. Would you have me extra long? And I've talked to myself dry. He went to both trials and thinks he never even came inside the last one. When he was in court in Virginia, he sat in the cafeteria and watched it on the stream and then commented. I guess maybe it was live tweeting then. But it was on a, oh, I know I have another update for you. This is nothing major, but okay, so all the court documents that were unsealed were made available to the public at a cost. And, we raised the money to pay for that. Fairfax has always taken the position that the court reporter owns the transcripts. And it's not that they're not available to the public. The court just felt that the copyright belongs to the court reporter. Therefore, if you want them, you buy them from the court reporter, and therefore she gets the money because she did all the work. Now, you can kind of go by what's on YouTube, but they make so many mistakes. But even she could make a mistake because when she does the transcripts and they have to be sent over, when she goes home at night, she reviews them and makes sure there's no mistakes as far as typos or whatever. So she has to fix them all. So it's a lot of work. So apparently there was a ruling that said, yes, Fairfax has to make the transcripts available, but they're at cost. We're talking thousands upon thousands of dollars to buy them. And I'm just talking about maybe even for one hearing. I'm not even talking about for an entire days. So yeah, apparently if y'all want to go crazy and go get transcripts, just you got to pay for them big time. So either way you could get them. It's just a matter of who you paid for them. And I guess Fairfax Court didn't want to be the broker. They felt that the court reporter owned the copyright because the courthouse does not hire her. The parties do. The parties do. So they just felt like, our hands are not involved in this. So that was the update I got on that. And we've seen that flying around like, oh, they were hiding this. Nobody was hiding anything. Just you got to pay for it, people. Yeah, couldn't pay me because it is misleading. But I was I want to see this. I was an insurance broker, and she's lucky her insurance company still paid. Typically, they won't if it's slander or malice. She's lucky they didn't make her pay it back. Yeah, and I think Pam took that stance early on. So when it happened, they got screwed. And I think that's why they were funding the appeal. I think they really expected the anti-SLAPP to kick in and reimburse them. I understand it's about reputation, but by letting her off the hook, it doesn't look good. I disagree. She needed a thrashing publicly. JD is trying to move on. I get it. I think Fox had the best article saying he's a gentleman. He was damned either way. If he went and tried to, he has to file court papers to get the judgment. I mean, if she doesn't have the money and she refuses to pay, he can't just to go rob her. He's got to go file in various venues wherever and track her down to get the money. So that would be a huge expense, number one. Number two, she'd probably file foreclosure, either a bankruptcy, even if it doesn't wipe the judgment away, she just has no money. And number three, it would look like Johnny went after a single mom with a baby. He already won. He already dragged her through the courts. She's humiliated. She'll never. What more does he want? And I think he was a gentleman. He did the right thing in saying, "Look, let's negotiate whatever you can pay." Travelers, she says, "I don't have any money. I can't pay anything." Travelers said, "Look, let's cut our losses on this crappy amicus briefs and appeal. We're going to lose. We're not going to keep throwing bad money away. We're not going to keep doing it. So let's just how about $1 million?" Oh my God, Agnes, did you see that thing I posted? Oh, I died. A guy in the hospital, I guess they gave him some drugs and he was singing the Muffin Man and somebody was recording it and said, "Is that the Muffin Man?" He was the Muffin Man. Oh my God, it's hysterical. It was something on Instagram, one of the reels. So yeah, I think Johnny did the right thing. I think he did the only thing he can do. And the other thing that I'm hearing from everybody, as far as future lawsuits, etc., he cannot live his life in the courts. He got screwed over by his managers. He got screwed over by his first attorney, right? You just can't live your life in the courts. He got screwed over by the son, the judge, for sure. He won with Amber. But how many years now has he been involved in court battles? He needs to live his life. He needs to get out. That's just no way to live. It's just no way to live. He needs to get on with his life, get out of the courts, do his music. Yes, Hollywood Vampire's coming up. Do his acting, do his artwork. He's doing a lot of artwork and just enjoy his life. He's at an age now where he deserves that. He doesn't have to do these franchise movies like he did when he was working nonstop, 3, 5, 6 movies a year. Yeah, I think she wanted him dead. I think she still does. It's so draining and so expensive. And, I hear this like right now with Nate, the lawyer. He's suing Boozy. I hope it works for him in the long run. But he's a lawyer, so he can do some of the work himself. Because it's exhausting and it's expensive. And even if you're right, and even if you're going to win, let's say it's the other way around, and you're the defendant. Even if you're going to win, and you know you're going to win, and you know they have no case, it's just so expensive and exhausting. And in the end, in America, you pay your own way, people. You pay your own lawsuit. You pay your own legal fees. Nobody pays for you. I got something on my face the whole time. I thought it was on the screen. Oh. Yeah. They're never prepared for how loved Johnny is. They keep complaining about the trial being publicized. Well, first of all, that was by the judge's own order. She wanted it. She didn't want the courtroom filled up with people and have to worry about security. She didn't want hire more security people that they just didn't have the people for. She wanted a fair and transparent trial. She wanted Johnny to have both of them, not have the media get involved. If it was out for everybody to see, you can't twist anything. So, yeah, it was on her own order. And nobody can complain about that. Amber didn't want it, and Elaine blew it and screamed to the world that, oh, yeah, by the way, we're going to claim this. It was supposed to be private. So, yeah, thank God for that, because the media would have completely twisted it against Johnny, no matter what. And they tried to. They tried to. But I was going somewhere with that thought. Oh, so what we're getting now is the trial caused so much public involvement. The public was not involved in that courtroom. The public was not involved with that jury. The public did not influence that. The judge was very strict if anybody laughed or was talking or discussing, and she booted you out. So, no, this did not come into play at all in that courtroom, in the defense, in the offense, on the jury. It did not play part of it. Her stands can twist it all they want. We've heard. Yeah. All right. I think that's it, guys. Unless you have any other questions I've missed. I think I've covered all the controversies. And I'm looking forward to Andrea covering this more in depth, because I was intrigued about her saying there's no controversy, because then the judge in this court, federal court, won't hear it. And how is Travelers going to feel that? Because that's what Travelers has been saying all along. No matter what I do, I have stuff. So yeah, so I get to get my hair done tomorrow. Sorry guys, you're gonna miss it. Is what it is. It's life. So glad it was televised. Oh my God, when they reported that Momoa took the stand, you just knew what a mess it was. Oh, the eyebrow. I'm crying so hard I got tears coming out of my forehead and my eyebrows. You're always, thank you very much. Granny, thanks for taking the time to go through all of these. I'm an insurance worker geek, and I live for all these deep details. You're a star. I hope I did it justice today, because I really do feel rusty. But I find it intriguing and interesting about two insurance companies for the same case taking completely different sides. And I did a poll, and I asked people, who would you want your insurance company to be, right? And I'll be honest with you, I'd want Travelers to go to the mat for me. I really would. I'm not saying New York Marine is wrong. I'm not. I see it. I don't have a document up, guys. I don't have the links down yet because I don't own it yet. If that's what you mean by you can't see the document, I'm just talking now. Although I was pretty bad at it earlier. But, yeah. I don't remember what I was saying. I don't remember. Oh, crying through her eyebrows, through her forehead. Using a tissue and not blowing her nose. Did you notice that? She'd use a tissue, take it away, and then she wiped on her sleeve a couple times. And I'm like, okay, I understand you might not want to blow your nose into the mic, but you got tissues there. Why are you using this? Things didn't make sense. She used eucalyptus or something to try and have tears. And all it did was make her nose run. Because she can't cry. She can't fake cry, per her own witness. I would where are you going? Comments going, but would travelers defend a regular person the same way? Again, I really think they were relying on the anti-SLAPP. So if you were in a position where you could evoke anti-SLAPP, maybe. I appreciate y'all too. I don't think she did a bump. Is that what everybody was saying? She did a bump. Wait, it went so fast, I lost you. She took, where'd you go? Oh, there. I don't think she did. I think she was putting eucalyptus or something, like she was trying to, she didn't want to do it before she took the stand. She was waiting for an emotional moment. She said, okay, I'll bring on the tears. And all she did was make her nose run. That didn't work. Yeah, the CD. I'm so thankful I got it. I got a glass case to frame my t-shirt. I'm waiting for some photos that I want to include in the shadow box. And then I will show you all what I did. I'm really excited about it. Johnny Depp's Never Fear Truth NFT have put out merchandise. I encourage you to take a look at that. They've got postcards, necklace, scarf. What else have they got? I think that's all they got. I can't remember. They have 2 sets of postcards, one in black and white and one in color. Vicks, maybe it was Vicks. Yeah. It was something to make, it was supposed to make her eyes water, except she stuck it up her nose. That didn't work. Yeah. So heartfelt condolences for Johnny, for Jeff's wife, Sandra, his family, Johnny's team. I'm sure they're all, this is such a shock. I'm all devastated. And I think he was at the hospital. So those pictures you see of Saudi, I think were right. I think he got the news and he left, which may have been this weekend. I mean, the weekend before. You know, it's gone so fast already. All right, I'm going to sign off. I love you all. So glad to be back. I'll probably be going down to 1 a week unless we get more insurance documents. I don't know that we're going to, I mean, if we get some great new stuff on Johnny. I'm not one like Tug and Andy to jump on for 10-minute videos with a news headline. I don't do that. Enough people do it. That's not me. Plus, sometimes I'm babysitting. I can't exactly leave the baby and jump on to read a headline. But yeah, I am so happy I got to meet him. I cannot tell you what a kind and sincere, humble man he is, that he took time with us, that he wasn't letting anybody rush him. And yeah, I made the right choice, boy. Didn't we? We made the right choice. Even after the UK, we could see what a debacle that was. We made the right choice. See you soon. Take care, guys. All right, I'm going to do my outtake, and I'm going to go cook dinner. Love you all. See you soon. Take care.